Our next speaker is Madame Routh Bolomet. She is a descendant of the royal line of the Kamehamehas, the original rulers of the Hawaiian Kingdom. As such, she is an heir to the privately held lands of the Kamehamehas and is advocating for the repatriation of lands that were taken and sold illegally under the regimes of the U.S. territory of Hawaii and the present U.S. state of Hawaii. Madame Bolomet, the floor is yours.
Aloha kako. Hello everyone. Thank you for taking the time to join us in our very important discussion on the impacts and injuries in the Hawaiian Islands resulting from UN General Assembly Resolution 1469. My name is Routh Bolomet. I'm a direct heir of King Kamehameha I through his ha'ili'i wife, Peleuli Kekelaukalani, and their heir apparent son, Prince Kaho'onoku Kina'u. King Kamehameha I was the unifier of the Hawaiian Islands into one royal kingdom in 1810 after years of conflict. This undisputed conquest under international dynastic law recognizes King Kamehameha I and his family as holders of the allodium to the Hawaiian Island archipelagic state. As a Kamehameha I and III heir, I make my diplomatic protests against UNGA Resolution 1469 and the U.S. usurpation of the Hawaiian Kingdom government through their fraudulent annexation and disingenuous report A4226 submitted on September 24th, 1959 to fulfill its requirements in Article 73E of the UN Charter. Public international law regards the illegal effects of protests against usurpation of sovereignty applies to republics as well as to monarchies. Accordingly, matters pertaining to de jure governments in exile are matters of public international law. The de jure sovereignty of a government which has been usurped by a foreign conqueror is not extinguished by such usurpation, but survives as long as such sovereignty is kept alive by competent diplomatic protest. The international public laws explain the value and purpose of my diplomatic protest as direct heir of King Kamehameha I and III. My diplomatic protest against UN General Assembly Resolution 1469 centers upon the fact that the description of Hawaii, the 50th state, fails to include any of the Hawaiian Islands, even though the name Hawaii alone gives the impression that the U.S. 50th state is supposedly located in the Hawaiian Island archipelagic metes and bounds. The name of Hawaii is derived from the discoverer, Hawaii Loa. He named the first island after himself, Hawaii, and the second island he discovered he named after his son, Maui. Now, this is significant because the U.S. cannot say that they are the creator of the name or the originator of the name Hawaii. The unlicensed use of Hawaii in UNGA Resolution 1469 and Hawaii, the 50th U.S. state, implies to the international community that the U.S. is located lawfully in the Hawaiian Islands, when in fact, what it actually explains is how the U.S. has openly and unlawfully occupied our islands without question from the international community. Resolution 1469 essentially makes the UN complicit in the U.S. illegal occupation in the Hawaiian Islands and the resulting injuries because it failed to recognize that the description provided by the U.S. to the UN General Assembly in 1959 failed to include any of the Hawaiian Islands. In their jurisdictional description found in U.S. Report A4226, Annex 2, page 1, Section 2. By the U.S. using our trade name, the UN incorrectly assumed the 50th state and the Hawaiian Islands were one and the same. Many diplomatic protests have been made on behalf of the Kamehameha heirs to the United States of America, President, and U.S. Congress since 1893 regarding the illegal usurpation of the Hawaiian Kingdom government and the unlawful taking of Kamehameha III's private estate. History shows our protests have been ignored. So, what is Hawaii, the 50th state? It's nothing more than a corporation registered in Washington, D.C., far outside and away from the Hawaiian Island archipelago. The historical overview of the deception. Specifically, what made Report A4226 disingenuous is that it was designed to intentionally give the illusion that Hawaii, the 50th state, was located in the Hawaiian archipelago. To achieve this, they first used our trade name, Hawaii, that was used to label the 50th state. found in Annex 2 of the report, page 1, section 2. However, in its boundary description, the U.S. failed to include any of the Hawaiian Islands found in our Hawaiian Island archipelagic metes and bounds when it was describing Hawaii, the 50th state. Today, if one is to use the trademark name in commerce that did not belong to that person or company, that would be a trademark infringement. If one company takes another company's name and uses all the goodwill, benefits, and privileges associated with that name, we'd call that identity theft. Even regional names associated with foods under the Appalachian law prohibits the use of regional names by those not located or products not located from that region. More misleading information can be found in U.S. Report A4226, which includes the alleged U.S. plebiscite to make Hawaii the 50th U.S. state, which only allowed American settlers and U.S. military personnel to vote. Second, the voters had to accept the new definition of Hawaii found in U.S. Public Law 86-3 that excluded all the Hawaiian Islands found in Hawaii, in the Hawaiian Island archipelago metes and bounds. Now, this is significant because U.S. Public Law 86-3 is the law that made Hawaii the 50th state, and it's essentially the bulk of the information that was submitted in UN Report A4226, submitted by the United States for meeting their criteria under Article 73E of the UN Charters. The Hawaiian Islands in the Hawaiian Island archipelago was recognized and has been recognized by many treaties and other independent nations in the family of nations, to include the United States in 1849, which they ratified in 1850. Furthermore, to this day, the U.S. Federal Jurisdictional Description of Hawaii, the 50th state, found in U.S. Title Code 28, Section 91, again, doesn't include any of the Hawaiian Islands. Even more astonishing is that the State of Hawaii Constitution, Article 15, in their boundary descriptions upon which the State of Hawaii asserts their authority, again, does not include any of the Hawaiian Islands. I presume the reason the U.S. purposely excluded any of the Hawaiian Islands in their jurisdictional description is because they do not have a lawful ratified treaty of annexation with the Hawaiian Kingdom. Now, this can be supported in the October 4th, 1988 U.S. Department of Justice memo to Congress on the legal issues raised by proposed presidential proclamation to extend the territorial seas. The opinions of the Office of the Legal Counsel can be found in Volume 12, pages 238 through 263, which confirms there was never a lawful treaty of annexation between the United States and the Hawaiian Islands. The Department of Justice goes on to say that they don't know how or by what legal form the Hawaiian Islands were acquired by the United States. As you already know, by international law, without a treaty of annexation, the U.S.'s uninvited presence in the Hawaiian Islands is nothing more than an illegal occupation, strange as it may be. The Hawaiian Kingdom legislature has never ratified a treaty of annexation, nor has the Kamehameha heirs, holders of the allodium to the Hawaiian Islands. We've never consented to relinquishing our sovereign rights or independence to the U.S. The good news is that the UN has mechanisms to address these grievous mistakes and has led immeasurable harm and injury to immeasurable harm and injury to the Kanaka Maoli and Hawaiian nationals. What is some of the harm and injury suffered in the Hawaiian Islands resulting from Reso 1469? Despite my own personal proof of heirship supported by probate court recognition, wills, birth certificates, marriage certificates, death certificates, censuses, and other certified filings accepted by the State of Hawaii courts and recording bureaus, the State of Hawaii continues to ignore my rights to land inheritances, continues to hold inferior warranty deeds superior to allodial titles. They continue to sell our inalienable private allodial title lands. They tax our untaxable lands and confiscate it when we refuse to pay their tax ransom. When warranty deed holders default, they give a bank with no standing in the allodial title land the right to confiscate and resell the land while dispossessing the allodial title heirs. The court and the administrative agencies of the state of Hawaii, under the watchful eye of the U.S., all participate in the theft or facilitation of the theft from family estates and trusts, which include forced, unlawful, private allodial title land sales to U.S. settlers and foreigners. The state of Hawaii executive officers, legislatures, judges, and attorneys are aware they have no authority in the Hawaiian Islands, and yet they perpetuate the fraud against the Kanaka Maoli and the Hawaiian nationals. They create statutes and administrative rules to permit themselves to build a 30-meter telescope upon the most sacred sites in the Hawaiian Islands, Mauna Kea. The state ignores all laws and protests to stop these actions, and the state facilitates unlawful arrests of our Kanaka Maoli elders who physically stand in the way of this travesty. The state, counties, and U.S. forces the removal of our burials in order to put in luxury hotels, parking lots, and U.S. military resorts. The military bombs and pollutes our sacred and cultural grounds, and the U.S. military's presence makes us a target of U.S. enemies. Non-Kamehameha heirs in the state of Hawaii administration wrongfully dip into the Kamehameha III's private trust to take salaries for themselves and to pay for unauthorized spending, all whilst denying any heirs of their right to a living from their inheritances. The state of Hawaii administrators, agents, and agencies use their foreign police to force Kanaka Maoli people by gunpoint off our private lands, whilst allowing their homeless U.S. settlers from other U.S. states to trespass and squat upon our lands rent-free. So, what's the remedy? Revoke 1469. The UN mechanism for reparation, when private property is confiscated, already exists. Holding politicians, officers, and soldiers accountable for expulsions and violations of the takings of private property in conjunction with the crime against humanity and genocide has already been established in the Nuremberg trials. The solution to ratifying this wrong can be found in UN Mechanism Article 10 of the Declaration on Population Transfer and the Implementation of Settlers, which states, where acts or omissions prohibited in the present declaration are committed, the international community as a whole and individual states are under an obligation, A, not to recognize as legal the situation created by such acts, B, in ongoing situations to ensure the immediate cessation of the act and the reversal of the harmful consequences, C, not to render aid, assistance, or support, financial or otherwise, to the state which is committed or is committing such acts in maintaining and strengthening of the situation created by such act. The mechanism gives the General Assembly the directive to correct the source of the ongoing harm and injury in the Hawaiian Islands. Besides the revocation of Resolution 1469, Report A4226 must be nullified as a source of the disingenuous act which misled the General Assembly in 1959 to pass Resolution 1469. The unauthorized use of our trade name Hawaii, our trademarks, associated trade names, copyrights, and intellectual property are all protected. Licenses were never granted to the United States of America or the State of Hawaii Corporation or any of the municipal corporations for which the right to use any part of the Hawaiian Kingdom name, emblem, flag, symbols, signs, hallmarks, or mottos associated with the Hawaiian Kingdom or its islands by any means or measure by the Hawaiian Kingdom legislature or the Kamehamehas, holder of the Hawaiian Archipelago allodium. As such, the U.S. must cease and desist from its use. Call to action. Because we have not been able to get resolution from the U.S. through its own legal apparatus since 1893, I, an heir of Kamehameha I and III, am coming directly to you, the member states, and the Hawaiian Kingdom treaty partners to request your assistance in the reversal of Reso 1469 and its harmful 61 years effects resulting from it. I call upon the President of the United Nations, the General Assembly, Secretary General, the Human Rights Council, all member states, and especially the Hawaiian Kingdom treaty partners, to set aside politics, review and confirm the disingenuous jurisdictional description of the U.S. 50th state, nullify report A4226, and to revoke Resolution 1469, which has and is bringing ongoing immeasurable injury and harm to the Kanaka Maoli and the Hawaiian nationals. After the UN Resolution 1469 has been revoked and report A4226 has been nullified, I request that the UN mechanisms found in Article 10 of the Declaration on Population Transfer and Implementation of Settlers be employed to facilitate the U.S. deoccupation from the Hawaiian Islands, to include the state of Hawaii and the municipal corporations, and to facilitate the negotiations for restitution, reparations, and restoration to the Hawaiian Kingdom and the harm and injury brought to it and its subjects. It is an erga omnes obligation of the international community as a whole and the individual member states not to recognize as legal the situation created by such acts, and in ongoing situations to ensure the immediate cessation of the act and the reversal of the harmful consequences resulting from Resolution 1469. Isn't it time to make right the wrongs resulting from UN Resolution 1469? Isn't it time to move forward in the spirit upon which the United Nations charters were built, which includes maintaining international peace and security while protecting human rights and upholding international law? Thank you very much for your time. Mahalo nui loa and aloha. I am Routh Bolomet.